What happens when the most powerful prosecutor in the county decides that a 9-year-old boy is a liability he can simply manage? This man walked into my courtroom with 15 years of institutional authority and the specific confidence of someone who has spent a career learning how to make inconvenient things disappear without leaving a visible mark. He had buried the case, reassigned it 4 times in 6 weeks, let 3 calls go unanswered, sent form letters where required, and the whole time a child was still in that home. He stood in this room, looking at me like this hearing was a procedural inconvenience, something to be absorbed and redirected with the right language, the way every other room had been. He had his folio. He had his aide. He had 15 years of practice at making the language of administration sound like the language of reason. And he said, with the flat certainty of a man who has never once been told that the room he just walked into is different, that the matter was under review, that resources required coordination, that the court's concerns, while understandable, should not be permitted to compromise the integrity of a prosecution his office fully intended to pursue. But what Lawrence Kane did not know, what he could not have prepared for, because nothing in 15 years had required him to prepare for it, was that an attorney named Clara Voss had been keeping a record. Every date, every reassignment, every unanswered call, every form letter, every week that a 9-year-old boy remained in a home while the case that should have protected him was being quietly suffocated. And when I asked Lawrence Kane one direct question, one question that required a plain answer, what he chose instead of answering it is the reason he no longer has a career. If you believe the law applies to the people who are supposed to enforce it, stay for every word. Case management hearings are procedural by nature. They move quickly, resolve administrative questions, and rarely require more than an hour of the court's attention. When the motion landed on my docket on a Tuesday afternoon, I noted the filing attorney set it aside and read it before the end of the day. I read it twice before I left. The motion concerned a woman named Nora Aldis, 58 years old, a licensed family counselor who has operated a free community clinic out of a converted row house on Pemberton Street for 11 years. Low-income families, foster children, veterans, the kind of work that happens in the gaps between every institutional safety net this city maintains, done by someone who decided 11 years ago that the gaps were not someone else's problem. 6 weeks before the motion was filed, Nora had submitted a mandatory report to Child Protective Services regarding a 9-year-old patient whose injuries were consistent with abuse. The subject of that report was a man named Patrick Souza. 3 days after she filed it, Patrick Souza's brother Derek cornered Nora in the parking structure adjacent to her clinic, blocked her vehicle, and threatened her, not vaguely, not impulsively, but with the specific cruelty of someone who had prepared her home address, her car, her schedule, named precisely. The responding officers documented it as one of the most credible and specific intimidation reports they had processed in years. Derek Souza was arrested within 48 hours. The case was assigned to the district attorney's office for prosecution. Then 4 reassignments across 6 weeks. 3 calls to the DA's office that Nora made herself, none returned. 2 formal written requests from her attorney, both answered with form letters. The 9-year-old boy was still in the home. And then Clara Voss filed a motion that required Lawrence Kane to come into this room and explain it. Lawrence Kane arrived at 8:51 a.m. in a dark wool overcoat, a single senior aide at his left shoulder, a leather document folio under his arm. He did not bring a legal team. He brought 1 aide and 1 folio because he had assessed this hearing as the kind of proceeding that does not require more than that. A case management matter to be redirected with the appropriate language and closed before lunch. He has appeared before dozens of judges in this building across 15 years and has, by every available account, never left one of those appearances without what he came for. That history was visible in how he moved, not hurriedly, not with the careful attention of someone uncertain about the room, but with the unhurried ease of a man walking through a space that has been consistently hospitable to him. He took a seat in the gallery's front row, rather than at the prosecution table, as though his presence this morning was a professional courtesy extended to a proceeding that would have been less without him. His expression, when he settled, was the managed patience of a man who has already composed his exit before the entrance is complete. Nora Aldous was already at the table when he arrived. Gray wool jacket, no jewelry, hands folded on the surface in front of her. She did not look at Kane when he entered, and she did not look at him when he sat. She had made, somewhere in the 6 weeks preceding this morning, the decision not to spend any more of her attention on what Lawrence Kane chose to project. Clara Voss sat beside her, 44 years old, 18 years in practice, the kind of attorney who keeps a file on her desk of every case where the answer was no until it wasn't. I entered at 9 a.m. and called the hearing to order, and Lawrence Kane began to explain. He presented a procedural brief his office had prepared. 3 pages, cleanly formatted, the work of someone who understood that the appearance of thoroughness is often indistinguishable from thoroughness itself. The brief cited case complexity. It cited resource constraints within the office's current caseload. It cited an ongoing parallel investigation that required coordination between multiple agencies before prosecution could responsibly proceed. Each element was described in the specific measured language of a senior official explaining a technical matter to someone who may not have the full institutional picture. The language that implies, without stating, that the person asking the question does not quite have the clearance to understand the answer. His tone throughout was the tone of a man doing a colleague a professional courtesy by being present at all. I listened to every word. Then I asked my first question. Mr. Kane, the victim in this matter, submitted a mandatory report under state statute. She was then physically threatened with documented specificity by a family member of the subject of that report. Your office has had 6 weeks and has not filed a single charge. At what point does resource coordination become something this court is required to treat as a different kind of decision? He recalibrated without visible effort. The investigation was ongoing. The parallel coordination was genuine and documentable. The court's concerns, while understandable, should not be permitted to compromise the integrity of a prosecution his office fully intended to pursue. He said it with the practiced fluency of a man who has spent 15 years learning that the right institutional language, delivered with sufficient confidence, has a way of making room stop asking questions. I asked my second question. Mr. Kane, who in your office is currently assigned to this case? He opened the folio. He gave me a name and a date, and both of them told me everything I needed to know. The assignment was 4 days old, the 4th in 6 weeks. I asked about the one before it. Kane described it as an internal administrative decision, a workload rebalancing, routine in a busy office. I asked about the one before that, another internal administrative decision, a jurisdictional clarification that had since been resolved. I asked about the first assignment made the week Derek Souza was arrested and when and why it had ended. A resource conflict, he said. Entirely standard. I asked him to produce the documentation for each transition. He said it was not standard practice to provide internal reassignment documentation to the court. I said, Mr. Kane, it is when the pattern of those reassignments is the basis of the motion before me. He did not produce the documentation. He said his office would make it available to the appropriate discovery process in due course. I noted that response for the record. Then I turned to Clara Voss and asked her to present the timeline. She placed a single document on the record, 1 page, every date in the 6-week period entered in sequence. Each reassignment, each of the 3 calls Nora made to the DA's office. Each date, a call went unreturned. Each formal written request from Clara's office, the date each form letter response was received. The pattern it described did not require annotation or argument. It was simply there, in the specific, unavoidable clarity of someone who had understood from the first week that what she was documenting was not administrative delay. It was administrative architecture. Kane's aide leaned toward him and said something quietly. Kane did not respond. He looked at a point slightly above and to the left of the bench with the stillness of a man performing composure for an audience he is no longer entirely certain is persuaded. I studied the timeline for a long moment. Then I looked at Lawrence Kane directly, and I asked him the question. I asked it at the same volume I use for everything in this courtroom. No adjustment in register. No pause to signal that what was coming was different from anything else this bench had asked that morning. Mr. Kane, I want to ask you something plainly, and I want a plain answer. Is there any relationship between the subject of the mandatory report in this case, Patrick Sousa, and any individual or entity that has had financial involvement with your office or your campaigns? In the past 5 years, the courtroom went very still. Kane's aide rose from his seat. I raised one hand without looking at him. I asked Mr. Kane. The aide sat. Kane looked at me with the expression of a man who has spent 15 years in rooms like this one and has developed a precise internal instrument for measuring exactly how close to a line he can stand without crossing it. That instrument was, in this moment, failing him because the line I had just drawn was not the line he had been measuring against. He said, "That question is not within the scope of this hearing." I said, "Mr. Kane, the scope of this hearing is whatever I determine it to be." What followed was not the silence of a man composing his answer. It was not the silence of a man deciding how to frame a response that serves his position. It was the silence of a man who has just discovered that the room he is sitting in does not operate by the rules that every other room has operated by for 15 years, and who has no prepared language for that discovery. He did not answer. And in a courtroom, that kind of silence answers everything. I turned to Clara Voss. I asked her how old the child was. She said 9. I asked if he was still in the home with the subject of the mandatory report. She said yes. I was quiet for a moment, not because I was uncertain about what came next. I had known what came next since the Tuesday afternoon I read the motion and understood what the timeline required this court to do. I was quiet because some decisions deserve a moment before they are spoken aloud, not for drama, but because the weight of them is real and this bench does not pretend otherwise. Then I issued 3 orders. First, the case was removed from the district attorney's office effective immediately and referred to the state attorney general's office for independent prosecution. The documented pattern of reassignment and non-response constituted a conflict of interest sufficient to require prosecutorial recusal. Second, a formal referral was transmitted to the State Bar's Prosecutorial Conduct Oversight Board, citing the timeline entered into evidence and the district attorney's non-answer to a direct question regarding donor relationships. Third, an emergency protective order was issued for the 9-year-old boy, placing him in temporary supervised custody pending the Attorney General's review of the mandatory report and the parallel child welfare investigation. I noted for the record that the district attorney's non-answer to a direct question regarding potential conflicts of interest had been entered into the transcript and would remain there permanently. Lawrence Kane stood. His aide stood simultaneously. He turned, not to me, not to Nora Aldis, not to Clara Voss, to the aide beside him, and said in a voice that was still performing composure it no longer entirely had, that his office would be responding to these orders through the appropriate legal channels. I said, "Mr. Kane, you are welcome to respond through any channel you choose. The record will be available to all of them." He walked out. The courtroom watched him go. Nora Aldis did not watch him go. She was looking at Clara Voss. Clara Voss was looking at me. The State Attorney General's office accepted the referral within 24 hours. Derek Sousa was charged formally within the week, aggravated assault, criminal threatening, and witness intimidation. He entered a guilty plea 8 weeks later. The 9-year-old boy was placed with a foster family during the investigation and did not return to the home. The Prosecutorial Conduct Oversight Board opened its formal investigation into Lawrence Kane's office within 30 days of the referral. The investigation ran for 7 months. What it found was not an isolated administrative failure. It was a pattern documented across 4 cases in the preceding 3 years, in each of which prosecution had been delayed, substantially reduced, or quietly dismissed, and in each of which the subject had demonstrable financial connections to Lawrence Kane's campaign operation. The amounts varied. The mechanism was consistent. The board's report was delivered to the state legislature in full. A special committee was convened within the month. 11 months after the hearing, Lawrence Kane released a statement, and what it did not contain tells you everything about what the morning in that courtroom had cost him. The statement was 3 paragraphs, clearly prepared by someone who understood that the safest document is one in which the fewest possible things are named. It did not mention Nora Aldis. It did not mention the 9-year-old boy. It did not mention the hearing, the motion, the timeline, the 3 orders, or the question that had been asked at the same volume as everything else and answered with silence. It did not acknowledge the pattern the conduct board had spent 7 months documenting. It did not use the word donor. It did not use the word recusal. It did not use the word conflict. What it said was that after 15 years of dedicated public service, Lawrence Kane had made the decision to pursue opportunities in the private sector, that he was proud of the work his office had accomplished, that he was grateful for the trust the county had placed in him and intended to carry it into the next chapter of his professional life. 3 paragraphs. The language of a man who has finally encountered something that the choice of words cannot manage, because the thing it cannot mention is already in the public record and will remain there, regardless of what the statement chooses to say. Clara Voss was appointed to the Prosecutorial Accountability Advisory Panel, convened by the Attorney General's office in the wake of the investigation. Her first recommendation was a mandatory disclosure protocol, recusal thresholds, donor relationship transparency, enforceable timelines for case assignment. It was adopted statewide within 18 months. The clinic on Pemberton Street is still open. The converted row house has a new room, added the year after the hearing, funded by a community donation campaign that raised 4 times its goal in 11 days. It is small, a low table, chair size for children, a shelf of art supplies, a window that faces the street. It is not a remarkable room. It is exactly what it needs to be. The 9-year-old boy has been attending sessions at the clinic since his placement stabilized. He is in 4th grade. He likes drawing. He draws the same thing most weeks, a house with a tree beside it and a door that is open. He has not been asked to explain it. He does not need to. Nora Aldis is still at the clinic. The same hours, the same work, the same converted row house she has operated for 11 years. Clara Voss is still taking the cases no one else will. I keep the timeline in the top drawer of my desk, not as a reminder of the orders I issued, as a reminder of what 11 years on Pemberton Street looks like when someone with 15 years of institutional power decides it is a manageable inconvenience, and as a reminder of what this bench exists to do when it is not. The door on Pemberton Street is open. It has been open for 11 years. It will be open tomorrow. I want to say something directly to everyone watching this. Lawrence Kane walked into that hearing with 15 years of institutional authority and the practiced fluency of a man who has spent a career learning to make inaction sound like process, to make burial sound like coordination, to make a pattern of decisions protecting a major donor sound like the ordinary resource management of a busy office. He had done it before. He had done it. The conduct board found at least 4 times in 3 years, and it had worked every time, because the rooms he did it in had allowed it to work. What he did not bring into this room was an answer to a direct question, and in a courtroom, the absence of an answer is itself a record. It cannot be managed after the fact. It cannot be appealed or reworded or omitted from a resignation statement. It sits in the transcript of a public proceeding and it remains there permanently, available to anyone who wants to understand what 15 years of institutional authority looks like when it finally encounters a question it cannot answer. The 9-year-old boy whose mandatory report started all of this is in 4th grade. He draws a house with a tree and a door that is open. That is not a small thing. That is not an incidental outcome. That is the thing this bench exists to produce. Not the orders, not the referrals, not the prosecutorial accountability protocol now adopted statewide, though all of those matter, but the specific, irreversible fact that a door that was being held shut by the weight of 15 years of institutional management is now open. Share this. Subscribe. Tell someone who needs to hear it. The drawing is on the table in the new room on Pemberton Street. A house. A tree. A door that is open. That is what this room is for.